A Florida jury has concluded that a controversial application of the Stand Your Ground law was invalid in the shooting of an unarmed black man outside of a grocery store in Clearwater, Florida. Legal journalist Molly Barrows joins me now to talk about the verdict. This is a case that got a lot of attention, and it should have, after the Zimmerman case where the Stand Your Ground actually succeeded. I mean, for all practical purposes. It was basically more of a self-defense more than just stand your ground. But Mark O'Mara, who's a dear friend of mine, tried that case, and he said his focus really was less stand your ground is in relationship. It was more just common law, self-defense kind of argument.
Right.
This is give me the facts. This is a crazy story.
I know, it's so interesting all the way around because this law is so open to loose interpretation, if you will. So the facts of this particular case, you have a convenience store, Tampa area. The man who was accused of manslaughter, the one who shot the victim, Michael Dridjka, he was angry because the victim's girlfriend had pulled into a handicapped parking space and she didn't have the proper identification to do that. So they got into a little bit of a verbal altercation. According to witness statements, he was giving her a hard time. She just went on walking. Well, and her boyfriend, Michael McLaughlin, was in the car and with their 5-year-old child, and he gets out and basically shoves the other guy, Dridjka, who falls to the ground, and surveillance video shows that he's starting to walk away, and Dridjka opens fire and kills him, and he eventually dies. So basically, he said, I had to shoot. I was in fear for my life. I thought he was going to come back and stomp me and beat me, but the surveillance video clearly didn't show that. However, the Pinellas County Sheriff said didn't charge him because they said it was a proper application of stand your ground, and it wasn't until public pressure that the prosecutor came forward and charged him with manslaughter. I think it was a month later.
I think part of this has to do with the Dridjka. Okay, first of all, they couldn't call Dridjka to the stand because he was a Looney Tune.
Right.
Not that he was insane, but he was one of these.
He would pop off.
He would pop off. This was not the first time he did this.
Correct.
He would go to stores and malls, and he would find people parked in handicapped.
Self-appointed policeman of handicapped spots.
So a real nutcase, and it was impossible to put him on the stand. So they didn't really have the pure self-defense case. But the truth is, he shot the guy as he was walking away.
That's right.
And I think what this does is this legislatively in Florida, I don't think anything's going to change. I don't think this is the kind of legislature in Florida that is progressive thinking enough to understand a jury heard your facts about your stand your ground. This guy had no reason to shoot. And the point being, he was such an oddball to begin with.
And he had a concealed weapons permit.
Yeah.
So it made it okay. That's part of the reason why I think he had the gun. But like you said, if you're really trying to apply stand your ground, this isn't the best guy to be defending in this particular case. So I think what's great about the fact that the jury came back and said that it wasn't applicable in this case, that he was found guilty of manslaughter, basically says that this law is so open to interpretation that it turns into the jury's job now to hold law enforcement accountable.
Yeah.
Did you actually do your job when you allowed this person to use this defense, or did you do your job by not allowing somebody to use it? And, like I said, I think Florida was the first to pass a stand your ground law like this in 2005, but we already had Castle Doctrine type laws and other laws across the country that allow people to use self-defense. But what makes stand your ground different is that you don't have to retreat. If you feel like your life is in danger, or you're about to be imminently bodily harmed, or there's going to be the commission of some felony is imminent, I could just blow somebody away if I felt, oh, my life's in danger and I don't have to run. I don't have to retreat as a way to avoid the situation. Yeah,
the argument, I think, at some point was the man pushes him to the ground.
Right.
His argument, well, I thought the car was going to back over me, so I shot not the driver, but the non-driver, who, oh, by the way, was walking away.
And was a black man, another unarmed black man.
With an all-white jury.
That's right.
Let me just add that. It was an all-white jury, the black man that was shot. Yeah. So I think when you start taking a look at these facts, even though these are kind of, we're like a tree falling in the forest.
Right.
Where it comes to talking about what the Florida legislature is going to do.
I know. It's disappointing.
They absolutely will do nothing, and we'll see more and more of these. But, the killing of Trayvon Martin made the headlines back in 2012. Right. I don't know that this case this policy has been tested enough. This is probably, in my way of thinking, one of the first of maybe 10 or 12 first serious tests of a stand your ground.
I think you're right, and I think it's going to take additional public pressure in individual cases like this to really bring it to people's attention to think critically about it. Otherwise, people are just going to continue to use it as an excuse, I think, to justify murder.
Every nutbird in the world has a concealed weapon, and he shoots because he doesn't believe.
Ooh, I'm scared.
Doesn't believe that somebody ought to be able to park in a handicap. That was part of the case too.
Yes.
They showed that there was more malice in his mind than just simply the man retreating. It didn't have anything to do with man retreating. There was malice and anger in his mind when he shot, because in his head, this parking in a handicapped place was just
a big deal.
a big deal. Molly, thank you for joining me.
Thanks, Pat.
This is an important message for our nation's veterans. If you served our country in the military between 2003 and 2015 and you suffered significant hearing loss, you might be entitled to compensation, because the hearing protection you were issued may be at fault for the damage you suffered, but you need to act now. Your time to make a claim might be limited. Learn more at levinlaw.com/earplugs.